All right, let's talk about trespass to land. Now, you probably think it's pretty simple, right? Someone just walking across your lawn when they shouldn't be. But what if I told you the invisible boundaries of your property could stretch thousands of feet into the sky and just as deep into the earth? Yeah, it gets wild. Let's find out just how far your rights really go. So, to kick things off, here's a little puzzle for you. What in the world connects a high-flying airplane, an oil drill thousands of feet underground, and a simple advertising sign? I know, they seem totally random, but believe it or not, they have all been at the absolute center of huge legal battles that ended up defining the very boundaries of your property. So, what's the official definition we're working with here? Well, legally speaking, trespass to land is any unjustifiable and direct interference with the possession of land. Now let's focus on those key words, unjustifiable and direct. This isn't about, say, a bad smell or a loud noise from next door. We're talking about a physical intrusion, something actually crossing the line. And that brings us to this really crucial legal idea. Actionable per se. Sounds fancy, right? All it means is that you don't have to prove any actual damage was done to have a case. Think about that footprint on your lawn. Even if it didn't hurt a single blade of grass, the law says the uninvited interference itself is the problem. The simple act of crossing that boundary is enough. And yeah, that's a point that's so fundamental, we're going to spend a moment on it. The whole point of trespass isn't really about proving harm. It's all about protecting your right to have exclusive control over your own space. The law is there to stop people from just helping themselves to your property, even if they're not breaking anything while they do it. So how exactly can someone trespass? Well, the law basically breaks it down into three main ways. The most obvious one, of course, is physically entering the land. Easy enough. But number two is just remaining there after you've been told to leave or after your permission has run out. And the third one, which a lot of people forget, is simply placing or even just throwing an object onto the land. Yep, that counts too. Okay, so we've established that trespass is all about interfering with land. But that just raises an even bigger question, doesn't it? What does the law actually mean by land? Is it just the dirt on the surface, or is there more to it? The starting point for all of this is this incredible ancient Latin maxim, cuius est solum, ius est usque coelum et ad inferos. Basically, whoever owns the soil, it is theirs up to the heavens and down to the depths. So your property isn't just a flat 2D map. It's a three-dimensional slice of the earth. You own the surface, the sky above, and the ground below. But as we're about to see, the courts have had to get a little more practical about what up to the heavens actually means in the modern world. So it's really helpful to think of your property in these three separate zones. You've got the surface, the subsoil, and the airspace above. And the law of trespass protects all three. Now let's get to the good stuff and see how real court cases have drawn the lines for each one. And this is where it gets really, really interesting. I mean, these abstract rules only make sense when you see how they play out in actual real-life arguments. So we're going to dive into some of the most important and sometimes downright weird court cases that literally drew these invisible property lines in the sky and deep under the ground. All right, let's start by looking up. If your land really extends up to the heavens, does that mean a 747 flying at 30,000 feet is technically trespassing over thousands of properties every single day? I mean, common sense tells you that's ridiculous, and thankfully, so does the law. Just look at the massive distinction the law makes here. In the first case, Bernstein, you have a high-flying plane taking aerial photos. The court said, no, that's not trespass. Why? Because a property owner's rights only go up to a height that's necessary for their ordinary use and enjoyment of the land. But then you have the Kelson case, where an advertising sign was just poking out a few inches into the neighboring airspace, and that was a trespass. So what's the difference? One was a temporary thing way up high, the other was a low-level, permanent physical intrusion. That's the key. Okay, so the law puts a pretty reasonable cap on our rights, way up in the sky. But what about below ground? How far down does your ownership go? Are we talking a few feet, a few miles, all the way to the center of the earth? 2,800 feet. Just let that sink in. That's how deep an oil company drilled under a man's property without his permission in a huge case called Star Energy v. Picardo. The company actually argued, come on, it's so deep it couldn't possibly interfere with his use of the land. But the Supreme Court completely disagreed. They said it was a clear trespass. Your rights go deep, really deep.
Trespass can even happen in places you'd least expect it, like on a public road. Check out this bizarre case, Hickman v. Mazie. There was this guy who spent all day just pacing back and forth on a public highway that happened to cut through a farm. What was he doing? He was spying on the racehorses training there. The court ruled he was a trespasser. Why? Because the public's right to use a highway is for travel, not for setting up your own little amateur espionage operation.
So let's just quickly recap those key takeaways. Bernstein puts a limit on your rights in the upper airspace. Kelson protects your lower airspace from things like overhanging signs. Picardo confirms your rights go way down deep into the subsoil. And good old Hickman shows us that even when you're on public land, what you're doing there really, really matters.
Now, hold on. It's not a complete free-for-all. The law is smart enough to know that there are some situations where entering someone else's property is totally legal. These are what we call defenses to trespass, and they're just as important as the rules themselves.
And really, there are three main defenses you'll see. The most common one is just consent. You were invited or you had permission to be there. We call that having a license. The second is lawful authority. This covers people like police officers with a warrant or utility workers who have a legal right to enter. And the third, which is by far the rarest and most difficult to prove, is the defense of necessity. And when I say the courts are strict about necessity, I mean incredibly strict. This powerful quote from the famous Judge Lord Denning really explains why. It was from a case involving homeless families squatting in empty council houses. He argued that, look, while their situation was obviously desperate, if you allow necessity as a defense for that, then no one's house could be safe. So the defense is pretty much limited to true immediate emergencies, like, breaking into a house to put out a fire, not to solve a long-term chronic problem.
Okay, so let's get practical. Someone is trespassing on your property. We've established your rights, but what can you actually do about it? Well, the law gives you several options, which we call remedies. Your most common weapon is an injunction. That's a court order telling the person to stop the trespass and not to do it again. You can also sue for damages, but honestly, if no real harm was done, the amount you get will probably be tiny or nominal. And finally, there's this old remedy of re-entry, which basically means you have a limited right to remove the trespasser yourself. And this is where I have to give a serious word of caution. While the law technically allows you to use reasonable force to remove a trespasser, the definition of reasonable is extremely strict. If you go too far, you can easily end up in way more legal trouble than the original trespasser, facing criminal assault charges or a nasty civil lawsuit. It's a risky path. And that really brings us to our final thought for today. You've got these legal principles, right? Many of them are centuries old, and now they're being slammed up against technologies the original judges could never have even dreamed of. Where's the line between a high-flying plane and a low-flying Amazon delivery drone? How do deep drilling rights apply to something like fracking? The invisible boundaries of our property are still being drawn, and you have to think the next big landmark case is probably just around the corner.